very good day to Dr. Nazri and fellow friends. I am YIING. Today, together with me are Koay, Xian, Genevieve, and Xian. All of us are from Insurance Law Group 1. We are now presenting on categories of claimants that are allowed to file insurance claim. Prior to further discussion, let's take a look at the flow of this presentation. We will first introduce to you what claimant is. Subsequently, our content is broken down to insured party interest and third party. Lastly, my friend Xian will conclude our presentation today. First, you shall understand what is an insurance claim. It is situations whereby an insured event happens. For example, your car crashed over another or you accidentally fall from a staircase, and then you make a claim under the policy. In every insurance claim, there will be a claimant. According to International Risk Management Institute, claimant is a person making a claim. It's someone who files a request to receive payments under the terms of an insurance policy. Insurance law is not the same as the contract law, whereby a party is bound by the privity rule, means only the party to the contract can enforce it. However, instead, in insurance law, the persons who are not a party to the insurance policy are allowed to claim. Generally, there are three categories of claimants. Firstly, insured. Secondly, the party in whose interest and on whose behalf the policy was taken. And lastly, third party. Our discussion will be based on two types of insurance claims, which are general insurance claim and life insurance claim. Insured can be a first-party insurance claimant when an insured event happens, and later he makes a claim directly against the insurance company. Let's look at the chart. It is crystal clear that the insurer or policyholder is a first party in the policy, while the insurer, the insurance company, acts as a second party. The insurance claim should be based on the contractual claims between the policyholder and insurance company. With that, an insurer is allowed to claim because he is the party to the policy. So, insurer has the right to enforce a contract from the perspective of insurance law and the rule of the contract. To illustrate, if an insurer faced a hit-and-run accident, his personal injury was covered under the life insurance policy, and the car damage was covered under the general insurance policy. With that, an insurer is deemed to be the claimant when he reports a claim to his insurance company after he suffered the loss. The insurance company is thus taking up the liability to compensate the insurer. This will be elaborated more on the next present.
Good day, my name is Koay. I will be presenting about insurance claim under life insurance and general insurance. In respect of life insurance claim, there are two types of life insurance policy, which are life policy and endowment policy. Life insurance is payable upon death, whereas endowment policy is payable if insured survives beyond stipulated time. The supporting case is Ho Chok Son versus the Indian Overseas Bank, in which you had held a life or endowment insurance policy with the assurance code. The policy matured due to the payments on 1st July 1957. In this case, it focused on wrong conversions of check paid by insurance company to you. There is no questions in regards to you as a claimant under this life insurance claim. Next, regarding the general insurance claim, for example, in house owner policy, a homeowner who suffered damage to his or her house as a result of a fire is entitled to claim the compensation from the insured. In the case of Handy versus Baxendo, the policyholder or the insured was allowed to recover only those damages that were in the computation of the party to the contract at the time the policy was purchased. In terms of the types of claim in motor vehicle insurance, there are own damage claims and no-fault claim. Own damage claim is a claim for own damage if the accident was the insured's fault, with the conditions that the insured have a comprehensive policy. Well, the insured can make a no-fault claim from their own insurance company when the accident was not caused by the insured, but also with the conditions that the insured have a comprehensive cover. Moving to the next presenter, Jenny.
Good day, madams and my friends. I'm LING. Now I'll be presenting on the second type of claimant, which is the party in whose interest and on whose behalf the policy was taken. This type of claimant can be any party in which the policy was brought forth. For example, there can be an employee or a child which the insurance was brought by their employer or parents respectively. The insurance involved is usually a life insurance. In order to have the claiming rights, there is one condition that needs to be satisfied, which is the one that insuring the claimant, such as the employer or the parents, must declare at the inception of the policy that their interest is to be protected by the policy. To illustrate, we can refer to Griffith and Fleming case, where in this case, the husband and the wife brought an insurance policy which stated that if either one of them passed away, the another spouse will receive a sum of money. When the wife was died, the husband brought a legal action upon the policy to claim for the insurance. The court allowed the claim because it was presumed that the husband has insurable interest in his wife. While in Reed and Royal Exchange case, similar situation happened here, where the wife has brought a life insurance for her late husband. When the late husband was died, the wife acted as a claimant to claim for the compensation. The court allowed the claim and ruled that every wife is presumed to have an insurable interest in the life of her husband. Therefore, the wife can be the claimant of the policy and does not have the burden to prove the insurable interest in the life of her late husband. Next, I will pass the floor to Genevieve. Thank you.
Good day, everyone. My name is Genevieve LING, with metric number 273158. Moving on to the employer and employee. This can be seen in the case of Bank Bumi Putra Malaysia Berhad versus Muhammad Saleh, where the respondent was in the contract of employment with the appellant bank. The appellant purchased a group accident insurance policy covering various risks in respect of its employees. In 1983, the respondent was injured in an accident and suffered permanent disabilities. The appellant, as the employer, is entitled to claim insurance under the policy, and the amount payable in the respondent case was 75,000. This compensation claimed by the employer is to be held in trust on behalf of the employee, since the policy is for the benefit of the employee. Moving on to the party in interest, the party in whose interest and on whose behalf the policy was taken. In general insurance claim, any party in which the policy was bought for is the claimant, be they employee or child, with insurance bought by employer and parents respectively. Notably, they have to satisfy conditions where the one insuring them must declare at the inception of the policy that their interest is to be protected by the policy. If the insurance goods are subject to a hire purchase agreement, and where the policy clearly indicates that the owner of the goods can be insured, then the owner of the goods can be the claimant. This can be seen in the case of Malaysian Australian Finance Company Limited versus the Law Union and Road Insurance Company Limited. The applicant sold a tractor to Chong under hire purchase agreement. Chong took out insurance over the tractor with the respondent. The policy stated that the applicant was the owner of the tractor and money payable under the policy will be payable to them so long as they remain owner. The tractor was damaged and the respondent refused to pay to applicant as they are not a party in the policy. It was held that the applicant had rights co-extensive as the said insurance called him in instituting claims in its own name against the respondent, arising out of loss of the subject matter upon which coverage was provided by the respondent, by virtue of the endorsements appearing in the insurance policy. Now I'll pass to the next presenter to continue the presentation.
Thank you, Genevieve. Good day, I'm Xian. Now I will continue in providing the example of the party in interest. Looking at the case of Herban versus Tomlinson Limited, Tomlinsons were carriers of a quantity of tobacco for the owners. As was required of them by the contract of carriage, Tomlinson insured the tobacco on behalf of the owner, which was subsequently stolen under the circumstances which attached no legal liability to itself. Tomlinson claimed under the policy on behalf of the owners. The court held that Tomlinson was entitled to recover because, as a bailee, Tomlinson had an insurable interest in the tobacco because of their potential legal liability if they were negligent. This means that if the goods are lost or damaged, the bailey will suffer from the financial loss as he needs to compensate the bailer who was the husband. Therefore, Tomlinson could claim for the full value of the goods for the benefits of the owner of the tobacco, and the compensation must be surrendered to the third party who insured the one claiming. Next, the last category of claimant in insurance claim is the third party. A third-party claim is commonly referred to as a liability claim because someone else is liable for the injuries suffered by the third party. A third-party claim is filed when one has been in an accident that was not his fault, where the other party needs to pay for his damages. The other party will have at least third-party insurance, which covers third-party bodily injury or death, third-party property or car. If the other party is at fault, the third party does not lose his no-claim discounts as he will not be filing against his own policy. In short, in the case where the third party is the claimant of the insurance claim, it means that there is an agreement by the insurer to pay directly to the third party. You must be wondering, in general, the third party is not allowed to sue the insured insurer directly even though he knows that the insured has a valid motor policy. This is because of the privity of the contract principle, which prevents the third party from enforcing an insurer contract or policy between the insured and the insurer. The third party can merely take action against the insured to get the compensation. However, there is an exception. Referring to Section 97 of Road Transport Act 1987, a third party in a motor policy is allowed to claim directly to the insurer when the insured becomes bankrupt. Now, let my friend Xian further explain it to you.
Good day, my name is Xian. Now we are still discussing on the third categories of claimant, which is the third party. As mentioned before, Section 97 of the Road Transport Act states that a third party is allowed to directly claim with the insurer when the insured is bankrupt. And just for your reference, Section 97 shares a similar position with UK Act, which is under Section 1 of the Third Party Right Against Insurer Act 2010. And this section briefly stated that the right of the insured against the insurer will be transferred to the third party in the event of insolvency, and the third party may bring proceedings to enforce the right against the insurer. Moving on, the passenger can also be classified as the third party where he is suffering from the loss due to the accident that's not his fault, and he is entitled to make a claim for that purpose. There are two categories of passenger that can make the claim, which is the passenger that are carrying for hire and reward, or the passenger who are traveling because of work or to work. A case where the passenger has successfully made a claim is illustrated under the case of Chan Kut Fong and others versus the Welfare Insurance Co. Limited. In this case, the two company employees were traveling in the course of employment in the company motor van, and they crashed into a tree resulting from the driver negligence. And the two employees sued the company and the driver, and it was held that the insurance company was liable to indemnify the injuries of the two employees who were the passenger carried in pursuance of a contract of the employment. The claim covered the medical expenses, loss of wages, compensation for pain and suffering. Before we end, to recap, there are three categories of claimant that can file an insurance claim, which is the insured, the party in interest, and the third party. So for more info, may kindly refer to the reference that's stated. And that's all from us. Thank you.